Good morning, good afternoon, good evening, wherever you are. On behalf of the FIDIC board, I would like to welcome everybody to today's webinar, where we are reviewing 7 years of the FIDIC 2017 White Book. The webinar, the classic contract for clients and consultants, 7 years of the FIDIC 2017 White Book, has been organized by FIDIC Contracts Committee, a body which plays a crucial role in identifying and anticipating market demands, strategically positioning FIDIC and developing our approach to construction contracts. Those contracts are widely used as an industry standard across the international industry. The reputation is in no small measure to the excellent work of the members of the Contracts Committee under the fine leadership of the chair, Vincent Leloup, the founder and managing partner of Exequatur, who I'm delighted to say will be moderating today's webinar. The FIDIC White Book is one of the most widely used forms of construction professional services contracts currently being used in the global industry. The contracts represent the basic form of a contract of appointment between a client and the consultant. The book, which is well regarded for its fair balance of risk between the client, is intended to cover the minimum requirements of a typical appointment contract. The fifth edition of the White Book was published in 2017. And at the webinar today, our speakers, who are experts in their fields, will reflect on the use of the White Book in the marketplace over the last 7 years, drawing out lessons for users, FIDIC, and the wider industry. They will highlight the main features of the White Book, including the lessons, why it occupies such a strong sale ranking within the FIDIC suite of contracts, and examine the main benefits of using it, reflecting international best practice and ensuring consistency with the rest of the FIDIC suite of contracts. Given the excellent lineup of speakers that we have assembled for this webinar, I know that we'll be guaranteed an interesting and insightful discussion, which will certainly highlight the different facets of the FIDIC White Book and why it remains so popular in the international contracts arena. I hope that by the end of today's event, you will gain a better understanding of the use of the FIDIC White Book and the benefit it brings to contracts and the client-consultant appointment process. As I said, we have an excellent lineup of speakers of today's webinar, and I know they will bring some very interesting insights to the table. It now gives me great pleasure to introduce the moderator for today's event, the chair of the FIDIC Contracts Committee, Vincent Leloup, to introduce the speakers and take you through today's event. Vincent, over to you. Thank you.
Thank you very much, James, and good morning, good afternoon, good evening to everyone online. Pleasure to see you all, and I see that we have a lot of participants today, so this is great. So it's going to be my pleasure to moderate this webinar about the FIDIC White Book 2017 edition, which is very dear to my heart as being a co-drafter of the White Book, and the principal drafter at the time of the White Book was my colleague Mike Roberts from Mott MacDonald. So before we start, I would like to turn to the participants, and with this poll question to you all, could you mention whether you have experience working with the FIDIC White Book 2017 edition? So over to you. So the question is still open. I think we'll show the result, see the result soon. Right, so we have 34% of you using the White Book, having experience using the White Book 2017, and 66% not having experience with the White Book. So that's good. Huh? One of the purpose of this webinar was also to introduce the White Book to newcomers and to persons in the industry who might be interested in using it. Right, so let me first of all introduce my esteemed panelists who are joining us today. So we have Pieter Mattelaer. Pieter Mattelaer is the Deputy Group Leader of the Project Portfolio Management Group at CERN. CERN is, for those of you who may not be aware of that, CERN is a European organization for nuclear research, and it's based in Geneva, Switzerland. The group to which Pieter belongs is responsible for all large construction projects on the CERN side. Pieter obtained a master's degree in civil engineering from Berkeley in the USA, an architectural engineering degree from KU Leuven in Belgium, and he started his career at Arup in London as a consultant, and after 10 years spent in consulting engineering in the UK and in California, he joined DIMI Offshore, an international EPCI contractor based in Belgium. In 2015, he moved to Switzerland to lead the civil works for CERN high luminosity LHEC projects involving shafts, caverns, and tunnels from concept design until completion in 2022. Pieter's professional experience spans across different parts of the construction sector, and he worked on both above ground and underground projects, onshore as well as offshore, and is currently leading the design and construction of 2 new large and sustainable mixed-use tertiary buildings on CERN sites in Switzerland and in France, at least one of which was a mass timber structure. And CERN is also an organization, so acting as employer on construction project, and who's got a very wide and large experience with FIDIC forms of contract, having used various FIDIC forms across the year, whether Red Book, Yellow Book, Gold Book, White Book, also recently the 2021 Green Book. So it's a pleasure to welcome Pieter, who will be the employer's voice, the client's voice in the White Book context regarding sharing his views about the White Book. After that, we'll have and we'll hear from Jafar Khan. Jafar Khan is Assistant Group General Counsel at Mott MacDonald, an international engineering consultant with over 18,000 staff spread over 150 offices across the world. Jafar has worked in the engineering and construction sector for over 20 years, with experience covering Australia, the UK, Asia, and the Middle East. He has split his time between private practice and in-house. He has worked at Mott MacDonald for almost 10 years. Although he's now located in Melbourne, Australia, he assists the Group General Counsel with matters arising across the group and across the world, but with a particular focus in the Australia and the Asia-Pacific region. Jafar is also a member of the FIDIC Contract Committee, and so within this webinar, Jafar will share the views of the consultant regarding the White Book. And last but not least, we will hear from Stephen Davey. Stephen Davey is a partner at Lockton, the world's largest privately held and still family-owned insurance broker, with annual revenue in the region of $3 billion, and with 11,000 staff employed across the world, serving over 65,000 clients on their insurance needs in over 140 offices internationally. Stephen graduated with a master's degree in civil engineering before falling in the insurance industry, where he has specialized in professional indemnity insurance for 25 years. He joined Lockton back in 2008 and leads their London professional indemnity team with a focus on UK and international architects, engineers, contractors, and property consultants, and he specializes in finding solutions for complex construction project insurance, innovative PI placement structures, and creating bespoke policy wordings. So it will be a pleasure to hear from the view of Stephen as an insurance expert, and in particular, as you will see, we'll have some discussion about the reasonable skill and care standard of performance which is expected from the consultant in the frame of the White Book, and we will hear from an insurer's point of view as to this level of standard of care as opposed to fitness for purpose, and that's going to be the subject of our discussion later on today. So that's it for our panel. And before we start a discussion about the FIDIC White Book 2017, I just would like to bring everyone on the same page, and especially taking into account that we have 66% of you who are new to the FIDIC White Book. I would like to take advantage of this webinar just to give you a few highlights and the main features of the FIDIC White Book 2017. So the FIDIC 2017 Suite of Agreements, this is a suite that we published back in April 2017, and it's composed of three main agreements. So you have the White Book itself, Client Consultant Model Services Agreement, which is governing the relation between a client and a consultant. Then between consultants, and consultants may decide to team up in order to bid for a client's job. And when they do so, they can use our Model GV agreement, which is a consortium type of GV, meaning that there is a clear delineation of scope of services between the GV members. And of course, in the life of their project, a consultant may wish to subcontract some services, and when they do so, they can use our subconsultancy agreement. So all three books, White Book, Subconsultancy Agreement, and a Model GV Agreement were published back in 2017, and you can find those on FIDIC website in the bookshop area. We will probably share a link with you through the chat area. So, in terms of history, the White Book 2017 edition is the 5th edition of the White Book. The first one was published in 1990, and the last one was published back in 2006. That was the 4th edition. In terms of the structure, what are the contract documents? What are the documents forming part of the agreement? You have as an equivalent to what you can find under FIDIC Works contract, where you have a contract agreement. Here we have a form of agreement, which is the top ranking document from a contractual standpoint. And the order of precedence of documents is defined under clause 1.15, which I put here on the screen. So you have the form of agreement, and I put an extract of this one on the left-hand side of the slide. Just after this form of agreement, you have this Model Services Agreement, which is composed of any particular condition that you may wish to add in order to either complement, supplement, or amend the general conditions. And the general conditions here are the terms, the general condition that you can find in the White Book itself. After that, you've got 5 appendices. I will come back to that in a minute. Appendix 1 is typically the terms of reference to be followed by the consultant. So the terms of reference that you put in your request for proposal to consultant and when you start the bidding process. Appendix 2 will be setting out what are the client's inputs to the job in terms of supply of personnel, in terms of putting offices at the disposal of the consultant, etc. Appendix 3 is about the remuneration terms that will be followed throughout the contract life. Appendix 4 is all about programming issues, and Appendix 5 are the rules for adjudication, because as you will see, adjudication is one of the tiers retained for dispute resolution under the White Book. So In short, the main features of the White Book is that the agreement is in force as of the so-called effective date, which is a date of latest signature of the agreement by the two parties, the client and the consultant. The consultant will perform services. When I put here services with an initial capital S, that means it's a defined term under the contract, under clause 1.1. And those services are those stated in Appendix 1, which, again, as I mentioned, is terms of reference. And those services are to be performed as of the commencement date, which is defined under the contract, and shall complete those within the time for completion. The time for completion starts to run from the commencement date. The standard of performance which is expected from the consultant is reasonable skill, care, and diligence. And we will discuss a little bit more later on in the webinar about what that means concretely. Although the purpose of the services is to be taken into account, of course. So, for example, a designer might be required to design a wastewater treatment plant treating 100,000 cubic meters per day of municipal wastewater, all in accordance with the EU wastewater directive. That would be, of course, the objective of the services, but the consultant does not warrant the outcome and does not warrant that this level of performance will be achieved. And we'll talk about that in further details later on. The client is liable for information provided to the consultant, but there is a scrutiny duty from the consultant, and the client may have to provide some services to the consultant. So typically the provision of offices, sometimes also the mobilization of personnel to assist the consultant in the delivery of their duties. Services are subject to possible variations. So that's a new feature of the 2017 edition, where, as you will probably appreciate, we have tried to harmonize the language and the concept that we use across all of our FIDIC forms of contract. So those who are familiar with the FIDIC Works contract will be at ease with the language and the concept used under the White Book. So we have also services which are subject to variations, as we find in Works contract. Client is to pay the consultant as per details provided in Appendix 3, as I mentioned. Failure to pay can trigger a suspension of services, possibly a termination, similar principle as you can find under a works contract, and the consultant is to proceed in accordance with the program, which is a defined term, as you find also under the 2017 works contract. And that program is to comply with any milestone, and the overall time for completion, which will be set under Appendix 4. There is also now an express list of delays, which can provide for an extension of the time for completion, plus a compensation for exceptional cost incurred. The client can suspend and terminate at will, and also terminate for breach of a material term or condition of the agreement. The liability is limited to reasonably foreseeable direct losses and to a cap and in time. And also we have upgraded the language about liability in clause 8 of the White Book, so as to answer some of the comments which were made regarding the 2006 language used for liability provisions. And clause 9 defines that the consultant is to take out and maintain a PI insurance and a public liability insurance, plus any mandatory insurance according to applicable law. So, for example, if you work in France, you have an obligation at law to take an insurance for the so-called decennial liability, which is making the designer, together with the rest of the construction team, strictly liable within a 10-year period from completion of the services, of the work, for any structural defect or for any defect making the works unfit for purpose during that period of time. That's the specificity of French law, and it's an example of a mandatory insurance at law that may apply in your respective jurisdictions. And regarding dispute resolution, this is clause 10. So the first tier of dispute resolution is to refer any dispute to senior representatives of the parties in an attempt to amicably settle the dispute. The logic being, of course, that with senior representatives, that means typically people who are not working on the project on a daily basis and who are not attending all meetings between the parties, and people who can therefore have more emotional distance with the daily running of the job, and who have a good overview of the various matters at stake for their respective company. Those kind of people can effectively reach a deal for the interest of their own respective firms. And because of this emotional distance with the running of the job on a daily basis, the logic under that is that they may be able to reach such amicable settlement in an easier manner than people who are involved in the daily running of the job. And if that fails, an adjudicator will step in, and you find their provisions which are similar to what you can find in the FIDIC Green Book. And finally, if any decision of the adjudicator, because the adjudicator will issue binding decision, if any decision is challenged by either party, then the last tier of dispute resolution is international arbitration with ICC rules by default. So that's just a summary of the timeline under a white book with the effective date, the commencement date, which can be set in the particular condition, or by default, it's going to be 14 days within the effective date. The time for completion starts to run, and this is within that time for completion that the consultant has to reach completion of the services. You may have some key dates defined under the contract through Appendix 4, and also an obligation to submit a program within 14 days from the commencement date. The whole of the services are to be performed with reasonable skill, care, and diligence. In case the consultant fails to complete the whole of the services within the time for completion, so there might be some instruction before the expiry of the time for completion for acceleration of the rate of progress. There might be also some excusable delays from the consultant, which may increase the time for completion based on clause 4.4. And if finally there is a completion beyond the time for completion, there is no delay damages provision as opposed to what you can have under works contracts, and for reasons that we will discuss. But nevertheless, that would be an obligation which is breached, and therefore the consultant will be liable for general damages. Subject, of course, to, in that case, the client proving a loss flowing from that breach of obligation to complete on time. And finally, some provisions under clause 7 for remuneration and payment throughout the contract life, and a possible audit of consultant records also post completion through clause 7.6, typically to reflect what can happen when you have a financier such as a development bank who would like to have access to the consultant record to approve the legitimacy of the cost incurred, and a duration of liability which is set in time. So that's a very short summary of the timeline. You will find also under the white book a lot of detailed procedural steps to follow, and I think this is something that the market tends to appreciate. We had some feedback on the 2006 edition where practitioners were asking for a more detailed step-by-step process to follow for variations, for suspension events, for termination, for dispute resolution, and now you can find all this now set out under the White Book 2017. So in summary, the main benefits of the White Book 2017 is to provide full alignment with the FIDIC works contract. You will find the same concept, the same terminology, where relevant, of course, and where applicable to a consulting services agreement. And also for the role of the consultant when acting as engineer under a FIDIC works contract. So this is a typical suitable combination when you have a consultant acting as a FIDIC engineer under, say, a Red Book 2017 contract. So this is a natural reflection of that role through a contract between the client and the consultant, so the client acting as employer in the FIDIC works contract. The natural contractual link between the two is to go for the FIDIC White Book, especially because you have a clause which is subclause 3.9, which is providing for all this connection between the obligations of the consultant under the White Book and the obligation of that consultant when acting as a FIDIC engineer under a FIDIC works contract. This is also reflecting modern international best practice. When we drafted the White Book back in the days, we had made a thorough review of a lot of jurisdictions and the position of construction law and practices in those jurisdictions, and we reviewed standard national forms of consultancy services agreement in more than 20 jurisdictions. It's meant also to be concise and user-friendly and to provide for step-by-step detailed procedures to follow for key processes such as the ones I mentioned, variation, suspension, termination, dispute resolution, etc. Finally, where do we stand in terms of ranking? So interestingly, the chart I put on the screen is just a record of FIDIC sales over the period from 2017 when we published the White Book up to now, 2024. So as you can see, 4,000 White Books were sold in hard copy version during that time, which is placing the White Book at rank number 6 within the FIDIC suite of FIDIC suite of contracts, behind typical flagship products, Red Book, Yellow Book, and Silver Book. So it's a firm and good standing for the hard copies. And interestingly, the White Book is our top seller for electronic versions. So that's an interesting point to keep in mind. And in terms of the geographical spread, as you can see, it's quite diverse. We have a lot of sales in South Africa and the UK. Also, a lot of sales may, of course, derive from law firms based on those countries who may acquire the White Book for the purpose of serving their clients, not necessarily in South Africa and the UK, but elsewhere across the world. So I'm just highlighting this with the kind of precaution for the interpretation of this data which is put on the screen. But then you have purchases from Botswana, Germany, Netherlands, Japan, UAE, Denmark, Kenya, USA, and France. So that's the top sellers geographically speaking. So as you can see, quite diverse. Okay. Right, so without further ado, I would like to turn to our esteemed panel today I would like to start with you, Pieter. If you could maybe share your experience within CERN of using the White Book and what are the main benefits that you see to it?
Thank you, Vincent. So yeah, CERN is an international organization based in Geneva, but we have sites in both Switzerland and France. We're also bilingual, so the organization functions both in English and in French. So that led us to a few years ago translate the 17 White Book from English into French. And then we use the White Book in one or both languages in combination with a FIDIC construction contract such as Red Book, Yellow Book, Gold Book, or Green Book. The advantages for us are that we kind of try to ensure a seamless transition from the early design contract, consultancy contract, and then going into the FIDIC construction contract. So the consultant who will become later the engineer gets very familiar with the terminology and the concepts. And because in our area of Europe, there are still plenty of engineers who have not worked with FIDIC contracts. For us, it's kind of a good idea to have the consultant who will later be the engineer in the construction contract and will then effectively administer the construction contract. First using a White Book allows him to test drive this FIDIC type contract for his own purposes before he steps into that role of the engineer. Another advantage for us is that CERN is an international organization with funded by 23 member states. And so we have a concept of industrial return where CERN awards contracts, either services or supply contracts, to a variety of companies in the different member states. And as such, we're really interested in using non-country specific or country neutral contracts to give a fair chance to companies coming from any of the member states to kind of tender for contracts that we put in the market. and hence we can put them in the market in an English form for a more international audience, or we use then the French translations to target more the local market. And then I would conclude by saying that, yeah, from our perspective, FIDIC contracts as a whole, and by extent also the White Book, we deem them to be generally balanced and pretty fair on both parties. And so we modify them a bit for our purpose. We kind of create particular conditions that we often integrate directly in the general conditions, but we always try to aim to make minimal adjustments to keep kind of the majority of the FIDIC contract intact. Yeah, that's what I would contribute to the point.
Thank you very much, Pieter. Jafar, may we hear from you about your view as a consultant working with the White Book?
Sure. Thanks, Vincent. So just to go back to my previous role. So my previous role was regional head of legal, and I covered the Middle East, Asia, and Africa. And so that brings me to where I saw FIDIC contracts used. What I noticed was that FIDIC contracts were most often used, where the procurement laws had specific requirements as to risk profile, and then also B, where we were talking about large procurement routes and large procurement pipelines. So where was it most commonly seen? So where it was most commonly seen were where there were really large procurement projects. So places like Abu Dhabi, for example, we see them fairly often in Saudi Arabia. We saw them quite often in Dubai also, mainly because the government departments over there had fairly clear and strict procurement policies, and so therefore it allowed the department to draft a suite of contracts that complied with those procurement policies, and it would therefore use a full suite of FIDIC contracts, including the FIDIC White Book, as part of that suite. I, for example, was involved in drafting the suite of contracts for Ashghal in exactly the same way, that you can create a suite of contracts that are consistent right across the board, and FIDIC White Book being part of that. I also saw the same use of FIDIC contracts and FIDIC White Book throughout Asia and Africa, and in particular South Africa also. So next point. So from my perspective, or from the consultant's perspective, why do we like the FIDIC White Book? What is it about FIDIC White Book that makes it attractive? Well, as Pieter pointed out, and as was pointed out at the start, that it starts off with quite a balanced risk profile. It makes it easier for consultants such as Mott MacDonald to have the conversation with the clients, and to not go into a great deal of detail as to why that starting position is fair and reasonable. It's been endorsed by FIDIC. The top 5 items, if you were to ask me what the top 5 key items were that we actually applauded, that helped us to sign deals and sign contracts with a fair and balanced risk profile, these are it. If you could please scroll through, Vincent. So these are it: caps on liability, changes in law, reliance on information, scope of services, and variations, and fitness of purpose. So I'll just quickly canter through each of those as to why they're important for a consultant. Caps on liability. So as most of you who are in the consulting industry would know, our fees are fairly small compared to the whole CapEx. So therefore, if there is an error in our design, we really aren't in the financial position to then underwrite the entirety of the project. We simply don't have the capital, nor do we have the cash reserves to underwrite the project in that way. So we usually go for a cap on liability of about 100% of the fee or less. That in our mind is fairly fair and reasonable. Changes in law. We often see clients try to push the entire of the change of law risk down to the consultants. So therefore, we are left having to take the risk, even though at the commencement of the project, that's not something that we can price. That might be okay for a very short project, but it certainly doesn't work where we are the engineer who then has to do the construction supervision for a project that might run for 5 or 10 years. FIDIC takes a far more reasonable and balanced approach, whereby if there's a change that affects the services, we get a variation. Whereas if there's a change that affects us more generally and not the services, then it covers us for exceptional costs. Reliance on information. Often we'll have the client give us information and the client will say, well, you are deemed to have been able to check it and price it into your fee. Well, given the procurement timetables are often hardly longer than 1 or 2 weeks, there is no way known that you can reasonably expect the consultant to have reviewed, checked all the information and then price that into the bid. It just doesn't happen in practice. So therefore, going back to the FIDIC model of requiring the consultant to still review the information, so we still have that obligation, but where there's an error that we get a variation for it is a far more reasonable and balanced approach. Scope of services and variations. Those people who are in the consulting industry will know that the scope of services that we see all the time, what is effectively open services where we are required to have priced in not only the basic services, but also anything that is reasonably anticipated has to be included in our price. FIDIC takes a far more reasonable approach of having the full services included in the appendix, and there's a clear variation process or procedure broken into 2. One of the most balanced variation procedures I've ever come across. Broken into 2 because, first of all, the question is the instruction a variation? If there's a dispute over that, then that goes through the dispute process. Assuming that's agreed, if the parties agree that the instruction's a variation, that can then be pushed through to the consultant. And if the consultant doesn't agree with respect to the price, it's time charge. Fitness for purpose, as Vincent said, we will come back to that at a later point in time, but FIDIC makes it clear that the consultant only has an obligation to provide the services using reasonable skill and care. Vincent, back to you.
Okay, thank you very much, Jafar, for your views as to the preferred points within the White Book, and we heard also from Pieter about that. I would turn back to Pieter and just to inquire about any areas where you would like the White Book to be changed in the future, improved from your employer's perspective, and for the sake of a future edition.
Yes, thank you, Vincent. I think that it's kind of still a common understanding amongst employers that they view the White Book as a contract written by engineering consultants for engineering consultants. So even though Jafar referred to many reasons why it's kind of pretty fair and balanced, from our perspective, from time to time, we would recalibrate the balance a bit to basically ring fence certain issues that we feel quite strongly about. I have a few examples that I will run through. One issue that we come across often as employers is that if we tender for services in the market, that we get offers with a dream team included as part of the fee proposal, and then we struggle by keeping that dream team actually on the project, and that gradually that dream team deteriorates into a losing of certain key personnel. And so the White Book kind of refers to key personnel, but we'd like to see a bit more stronger language to make sure that that key personnel really stays on the project and that we kind of can maintain the team that was tendered with. Another one which consultants typically don't really like to talk about is maybe the addition of a performance security. As is typical in construction contracts, the majority of the FIDIC construction contracts have a performance security obligation for the contractor. The White Book doesn't have a performance certificate or security imposed on the consultant. It's something that we typically still do at CERN. In terms of variations, yes, there is a variation clause. From our perspective, the variation clause cannot be clear or precise enough because it's a typical discussion between employers and consultants. So from our perspective, what we have done is we've kind of taken some ingredients from the FIDIC construction contracts, and we've really decoupled the variation clause in a variation by instruction or a variation through a request for proposal. So we've, in a way, beefed it up. I think in spirit, it remains completely the same, but the procedure of discussing variations and agreeing on variations, yeah, cannot be clear enough for both parties because it's a typical issue. And then the concept of exceptional costs. From an employer's perspective, that is a bit too loosely defined. And so our legal team really made an effort to kind of ring fence it a bit more, to make it a bit more precise, to really know at the end of the day, exceptional cost for a consultant. What is that? When does it apply? And what are the rules of the game to have discussions on exceptional costs? And then I would conclude with something that we kind of think about on every project where we use a White Book in combination with then also a FIDIC construction contract, is both consultancy and construction contract include notions of an adjudicator or a board of adjudicators, a DAAB. And from our perspective, it would be nice if the same adjudicators or the same DAB would have jurisdiction to deal with disputes on different contracts, that we don't need separate adjudicator contracts for that deal with the White Book and then separate adjudicator contracts to deal with the construction contract. So in general, I think our changes are pretty limited, but yeah. From an employer's perspective, we try to put some extra security for us into a standard FIDIC White Book.
Okay, all right. Thank you very much, Pieter. So that was good to hear from your suggestions of improvement for the sake of a future edition. So I suspect that Jafar may have a slightly different view than you as a consultant representative here in this panel. So Jafar, would you like to share your views as to what kind of improvements you would like to see in the future on the White Book?
Sure, Vincent. Well, it goes without saying that that from a consultant's point of view, we certainly don't think that there needs to be as many changes. We actually think that it's relatively balanced to begin with. And I can see Pieter smiling there, but we can take that up afterwards, Pieter. But two areas of change that I would suggest. So the first one is the role of the engineers. So as Vincent mentioned at the outset, there is a particular clause in FIDIC in the FIDIC White Book to make it work with the works contracts, which deals with the role of the engineer. Many consultants find themselves in a difficult situation when they take on that role because of the fact that they are engaged by the client or the employer. And they're paid by the client and the employer, and often often the employer will struggle with the fact that they are giving a certain degree of autonomy and independence to the engineer, because the engineer in some instances is supposed to act independently and fairly. And because they struggle with that, they try to reel that back in to a certain extent. Now, the contractor, on the other hand, is relying on the engineer to act independently and fairly in those particular instances. And certainly in civil law jurisdictions, we and other consultants have found that in the event that there's a dispute between the employer and the contractor, that there is a real risk because of the way the civil codes work, that the engineer can be drawn into that dispute, and the allegation being either that the employer saying that the engineer has not acted impartially and not acted fairly because the employer does not agree, or vice versa, the contractor having the same claim. I do note that clause 3.9.4 quite helpfully tries to shield the engineer or the consultant to a certain degree, but I think that can be clarified. The instances where there could be breach and when the employer might have a claim against the engineer can be more clearly stated. What would be useful is to have a hold harmless there as well, and also having the contractor likewise waive rights in its contract that it might have against the engineer. I think that would also assist for that particular role. The other area, Vincent, that I've seen to be prone to a lot of disputes, certainly more recently, is because of the fact that the services are required to be set out in Appendix 1 of the contract, that the client automatically assumes that those services aren't time-bound, and the parties usually don't turn their mind to it. And one should, I guess, if there are services that are time-bound, for example, construction support, that the consultant doesn't take the risk of there being a delay to the construction program, and so therefore is deemed to have priced in that construction support to the end of the construction program. One would think that could be clearly set out in the appendix, but unfortunately then it's often not. And so what would be really good to see is for that to be specifically addressed in FIDIC White Book, that query or maybe have it in a separate appendix those services which are time bound. That's it from me, Vincent.
Thank you very much, Jafar. May I now invite Stephen? Now, Stephen, you are not acting as one of the parties in a White Book contract, but you are often taken to provide insurance coverage to consultants acting in the frame of the White Book under Clause 9 of the White Book. So could you share with us your view as to the White Book and its main benefits from your own perspective?
Thank you, Vincent. And we do act for all elements of the supply chain, so I'll try and keep this balance for Peter's benefit as well. And actually, I think there is a significant relevance, as you say. We're not practitioners ourselves, but the professional indemnity and sort of other insurances that we place on behalf of our clients, directly respond to claims for damages which are influenced and governed by the contractual terms agreed between the respective client, contractor and consultant teams. And as both Peter and Jafar have set out, but many of the benefits and improvements that have been talked about are really, really related to this. So I think it is very relevant. And as we're all aware, I think one of the main causes of insurance risk and liability exposure on any construction project, as opposed to acting singly as a lawyer or an architect, is just the amount of contractual interfaces. Even on a relatively simple project, we have the funder, the employer, contractor, architect, engineers, project and construction managers, property agents, planning advisors, etc. Even before you get into the specialist contractor and consultant supply chains. So what happens in practice is that whilst everybody's working collaboratively to complete the project, there's so many nuances of different forms of contract that even if the core contractor or consultants try and ensure liability terms are back to back, you sort of do get these variations. And I think that then becomes a challenge with insurance as well. So each party will have independent and separate professional indemnity insurance, different policy terms and conditions, different insurers, different renewal dates, different claims handling procedures, etc. So often when there is a dispute, we see that the strategy of some parts of the supply chain is often to argue around inconsistent or unaligned contract terms, rather than trying to focus on resolving the problem for the insurer. And I think what, as I'm sure Jafar will appreciate as well, is that what's happening at the moment across the insurance industry is the actual cost and defence costs of sort of dealing with these issues can often be more costly and time consuming than the actual rectification or damages involving the work itself. I think the other aspect that's very relevant is that because of the ongoing pressure on contractors due to inflation, material supply, workmanship issues, they've got so many upstream issues that they're then having to rely on heavily amended contract terms that they have in their subcontracts or consultancy agreements, if it's a D&B contract, to try and recover some of those losses via a contractual dispute, rather than there being pure negligence by the design team. So again, we've got lots of examples at the moment, particularly on large infrastructure projects, where the cost of purely defending claims can run into tens and tens of millions of dollars. So I guess to sort of bring it back to the White Book, regardless of whether those costs are paid by insurers, this all ends up being priced back into the wider pool of construction projects, because as Jafar said, consultants, contractors, they can't fund all these disputes themselves. So that sort of risk transfer has to be priced in as part of their contract bid. So insurers don't dictate what contract forms consultants and contractors can utilize. But as a broker, we spend a lot of our time working with our clients' legal and commercial teams to explain to insurers what our clients are doing to help mitigate some of these losses. And that's a really important part of sort of how their premiums are rated and the risk profile that they bring. So, I do think that PI insurers are increasingly aware of the types of form of contract that their clients and insureds try and enter into. And they, see some significant benefits around that sort of fair balance of risk, consistency in the application of the main conditions, and clarity, particularly in definitions in the FIDIC White Book. And there's been a lot of examples of those already, but I would just very quickly pull out a couple of them. Definitely clear scope of services. Not allowing additional standard of care obligations to be tucked away in these or other technical documents. Dealing again with sort of contract administration and variations. Having a really consistent methodology in how those are valued. We often see fee disputes around variations that can then manifest themselves in a counterclaim for negligence. And again, we've already discussed sort of arbitration and adjudication provisions, but again, having a really clear stepped process around there with everybody working together, really helps to minimize the sort of cost of some of those things. So I do appreciate that, both sides of any party will say, are they sort of fair and reasonable? But I think actually, if you look at it in the round, having a very fair, reasonable, clearly defined, easily understood contract like the White Book, can actually in turn reduce some of those frictional risks and therefore, costs that consultants and contractors have to build into that contractual price. So hopefully in the long run, Vincent, it's a win-win for all our parties.
Yeah, thank you very much, Stephen. I think what you mentioned is fully right. And what we see in practice is a lot of issues arising from the fact that people are amending our standard terms. And of course, some with the amendments which are brought through particular conditions of contract. And sometimes the issue with the language used can be actually the source of many disputes. And what you said in connection with insurance, I will take us to look at the beating heart of the White Book, which is the fact that the consultant is to perform the services with reasonable skill, care, and diligence. So I would like that we open a second part to our discussion in connection with reasonable skill, care, and diligence, as opposed to fitness for purpose warranty, which is a warranty given typically by a design build contractor under a FIDIC Yellow Book, or a silver book contractor. Jafar, maybe you would like to set out and explain to the audience these two different concepts, which are often understood with some difficulties, I would say, in practice by practitioners in the field. It's not always that clear for everyone, the difference between reasonable skill and care and fitness for purpose. So over to you, Jafar.
Thanks, Vincent. So if we could start off by just setting the scene here. So as Vincent was saying, I think the key issue here is what is fitness for purpose. We often see clients asking the consultant to take on a fitness for purpose obligation. But what does that actually mean? Well, it's actually good to understand what fitness for purpose means by way of comparison to what the starting point is in FIDIC. And as Vincent mentioned, that what consultants like to agree to is actually an obligation to undertake the services using reasonable skill and care. That is the starting point. That's the position that's currently drafted in FIDIC White Book 2017, and it's set out in clauses 3.3.1 and 3.3.2. So the key concepts here, 3.3.1, it requires the consultant to undertake its services using reasonable skill and care and diligence to be expected from a consultant experienced in the provision of such services for projects of a similar size, nature, and complexity. So that's one. So A is a standard, and then B, the yardstick against which that standard is measured. Then 3.3.2 adds a little bit more to that, and I'll come back to that in just a second. But just keep in mind that the consultant is also required to perform the services with a view to satisfying any function and purpose that may be described in Appendix 1. So there's an obligation in FIDIC White Book to actually define what the function and the purpose is in Appendix 1. That's to be kept in mind. So if we just go on to the next slide, and so on. So coming back to the question, what is the difference between fitness for purpose and reasonable skill and care? And why do clients sometimes ask the consultant to take on the obligation of fitness for purpose, and what does it actually mean? So coming back to the point that Vincent made, sometimes it's not always understood. I remember when I trying to negotiate this point with a client once, and I turned around and said, okay, so explain to me why do you want us to agree that the services are going to be fit for purpose? And their explanation to me at the time was, well, we simply want to use fitness for purpose to avoid you claiming for variations. And I just scratched my head and thought, well, they clearly do not understand what fitness for purpose means at all. So I thought, okay, now's a good time to actually go through it. What is the difference, and where does this distinction come from? So starting off with fitness for purpose and that term itself, I've heard people say that in certain jurisdictions, fitness for purpose does not apply. Well, it's not really a legal term or a term of art per se. As Stephen was saying, you often see fitness for purpose obligations tucked into schedules, and they're not called fitness for purpose. They're effectively and essentially what we are talking about is a warranty that warrants the outcome. And so there is the critical and key difference there. We as design consultants have only a certain degree of control over the outcome. We will undertake the design, but we won't actually undertake the works. And so that's why the consultants traditionally have only agreed to reasonable skill and care and not fitness for purpose. Because we don't undertake the works, why should we have to warrant what the works actually do? Now, what is the genesis? Where is the genesis of this from? So coming back to where this stems from, certainly in common law countries, that there's a principle of what they term the Boland principle, which is that where there's a professional, say for example an engineer or a doctor or a lawyer who is providing professional services, they are required to undertake their services or to provide their services using reasonable skill and care. And the yardstick against which that is measured is the skill and care that would have been taken objectively by a professional in the same circumstances. Where they fail to do so, they are then found to be negligent and to have breached their obligation to undertake their services using reasonable skill and care. And that's backed up by various legislation in countries, say, for example, the Sale of Goods Act in the UK and the Australian Consumer Law, which requires goods as opposed to services, materials as opposed to services, being fit for the purpose for which they are produced. And so therein lies that distinction between the standard that is required of a contractor who produces works or goods and a professional who provides services. And so that's the genesis of the distinction between the standard expected of a consultant versus that expected of a contractor. And so what are the arguments that the consultant uses? What do we say when the client asks us to agree to a fitness for purpose warranty? So the two key arguments is, as I was saying before, we only undertake the design. We don't do the work. So even if we're doing construction supervision, we aren't going to be supervising and overseeing every single part, every single detail, every single stone that is being laid in the undertaking of the works. And then secondly, we're not insured for it. And so that would then place an undue heavy burden on the consultant. But there is a particular conundrum, and that's something that Peter's going to come to. But let me just go through some facts to just explain this concept and what Peter's going to be talking about, which are the facts of the Hogarth case. So what we had in the Hogarth case was that the employer engaged a contractor to design, construct, and install 62 foundations for an offshore wind farm project. Part of the scope included the grouting connections, which were governed by the J101 standard. The contract stated that the grouting connections needed to comply with J101 and have a life of 20 years. So in that particular instance, the contractor actually designed in accordance with J101, but it was later found that J101 was inappropriate, sorry, not inappropriate, but insufficient. So the issue is, if it was reasonable skill and care, simply complying with J101 would be the correct standard. It would mean that reasonable skill and care had been complied with, because that's what would be expected of a consultant. However, the contractor, having agreed fitness for purpose, the problem was that the works did not have a life of 20 years. So that's an issue that Peter's going to be talking about, because therein lies the issue, which is that if you've got a D&C contractor that needs to agree to a fitness for purpose obligation, and the D&C contractor wants to subcontract the design to a consultant, and the consultant will not agree to that fitness for purpose obligation, then who bears the risk? Vincent, back to you.
Thank you very much, Jafar. I'm just sharing the link for the sake of everyone. I'm sharing the link to this case that you referred to and this decision from the UK Supreme Court, MT Hogarth against Iran. And talking about this case, and thank you, Jafar, for sharing your views as to the difference between reasonable skill and care and fitness for purpose, and the reason why consultants are not keen to take on and to give a fitness for purpose warranty for the reasons that you mentioned. I would like to hear from Pieter and from his viewpoint as an employer, but also his former life as a contractor. So, Pieter, over to you.
Yeah, thank you, Vincent. So the case as treated by the UK Supreme Court dates from 2017, but it has many years leading up to that ruling. And I also think that the internet is full of opinions or views as to how that case kind of played out in the courts. So whatever I add to that is just additional commentary and an opinion, and obviously I leave the facts for what they are. And so the case is kind of interesting for me because since 2015 I've been working as an employer, and from that perspective I like the case because it really demonstrates the solidity of a fitness for purpose obligation handed down to a contractor. But before I became an employer, I was working for a design and build contractor in exactly the same sector with basically a competitor of the contractor that basically lost this case. So I was also working in the sector of offshore wind foundations. And from that perspective, having been in that exact same position as a design manager, project manager for a DNB contractor, I kind of saw the difficulty to explain that to engineers, because maybe from a pure legal perspective, people can follow and understand this and kind of just say, yeah, fitness for purpose is holy. But from an engineering perspective, it doesn't really make any sense. So I'll recap a bit. So I won't use the names. The names of the companies are basically in that judgment. But what it basically boils down to is that design and build contractor gets into a contract with an employer and agrees to a fitness for purpose obligation, but he remains a contractor. The contractor had a very limited in-house design team, or basically just a design management team. So they outsourced the design to a consultant, a very renowned and basically market-leading consultant in that sector. And that sector did not agree to take over that fitness for purpose obligation. They probably worked under FIDIC Yellow Book, FIDIC White Book combination. So the White Book gave the reasonable skill and care. The contractor had fitness for purpose in the Yellow Book. And that led him to basically break the chain of back-to-back contracting, where he agreed to a higher level of security towards the employer than he could get from his consultant, passing on the design further downstream. But that makes that design and build contractor is massively exposed to any issue with the design, because he has outsourced it for, yes, a modest fee, but for that modest fee, that consultant designs works of a very high capital value. And that contractor is finally on the hook to make sure that a certain design life or the fitness for purpose obligation of the work designed by the consultant is guaranteed towards the employer. The particular details of that case also made it that the client, the employer, was pretty clear as to which design standard was to be used to design the foundations. It was a DNV standard called J101, which is kind of a really well-known standard in the offshore wind sector. The fact was also that DNV, who is a Norwegian classification and basically a third-party certification bureau, reviewed the design as it was done by the contractor's designer and approved it as being compliant with the standard defined by the employer. And as such, all of the quality checks were carried out. The designer used reasonable skill and care. The designer, in combination with the contractor, used the correct design standard, and the certification agency who had written the standard certified that the design was completely done in accordance to the standard. So in a way, on paper, nobody made a mistake until kind of a very technical mistake surfaced, which was that there was an empirical parameter in one of the formulas in that design standard, which hadn't been researched to a sufficient extent, and that empirical parameter appeared to be off by a factor of 10. And hence, from an engineering perspective, the real mistake was in a mistake in the design code. The design code was written by an external party, which was then contracted by the employer to carry out a third-party check. And hence, the contractor, the design and build contractor, nor his designer, in a way, did anything wrong. But still, from a legal perspective, because there was this fitness for purpose obligation, the contractor was eventually found liable to pay for the remedial work, which amounted to 26 million euros. And obviously, from a legal perspective, understandable, but from an engineering professional construction perspective, very harsh towards basically a design and build contractor who then had no recourse against his designer because the designer basically did his job, reasonable skill and care. The correct code was used. There was a mistake in the code. And I haven't found information on what eventually then happened to DNV and the author of the code. Maybe there are some rumors on that, but from an employer's perspective, I think the employer got basically a get out of jail card from a legal construction. But in my former life with a design and build contractor, I have difficulty swallowing that judgment.
Yeah, thank you very much, Pieter. And I think what you mentioned does echo a lot of reservations and a lot of comments we hear from practitioners regarding this case, because from a common sense engineering perspective, you've got on one side the designer who's been following the DNV standard. So basically, the designer has designed the works as per the book and as per the state of the art. So in essence, they did no fault at all in the design because they were following the standard at the time. And the standard is, of course, meant to reflect the state of the art regarding, in that particular case, offshore wind farm foundations design. So the designer did no fault and therefore could rely on the state-of-the-art defense and could rely on the fact that their contract was providing that they shall perform their services with general skill and care and diligence to avoid being liable for the defects on the wind farm foundations. While for the contractor, and because of the fitness for purpose warranty, the state-of-the-art defense does not work, and the contractor is on the hook because ultimately the foundations are not fit for the purpose intended and specified under the contract. So you are in a situation where the contractor is liable while the designer is not, and somehow both of them have followed the state of the art in terms of designing and executing those works. So that creates, of course, a difference, and which is often a question mark from practitioners. And it's just a matter of the law. The one having given the fitness for purpose warranty will be liable, while the other one will not be, the one working under reasonable skill and care. So it's important to remember that fitness for purpose warranty will generate a no fault based liability. Doesn't matter that you did no fault. It doesn't matter that you follow the state of the art. You will be liable just because the results which were defined under the contract have not been achieved. And this is, of course, very tough.
Yeah, but in the ruling of the Supreme Court, there was even a slight mention of the judge ruling that the contractor should have, in a way, benchmarked or double-checked the standard. And maybe from a legal perspective, that's a valid statement. But I think everybody working as an engineer in the construction sector, everybody would kind of immediately say, yeah, but if I'm using a standard and the standard is used widely throughout an industry, I am not supposed to check whether there are any mistakes in that standard. And that's, I think, where the engineering view or perspective on the world clashes with a pure legal view.
Yeah, and interestingly, regarding what you mentioned, in this MTHGuard case, obviously the parties were not working along a FIDIC Yellow Book form of contract, because had it been the case, arguably the contractor would have been able to benefit from a relief, because we have a provision which is our subclause 1.9 for errors in employers' requirements. And we have seen a few articles about that matter saying that a Yellow Book contractor could have argued that an experienced contractor at the time of tender would not have been able to spot the error in G101 standard, and therefore that would have given the contractor a relief under clause 1.9 on the Yellow Book. While, as a difference, if that same contractor was working under the Silver Book, there would have been no relief. So obviously, the main contract between MTHGuard and E.ON was not along FIDIC Yellow Book provisions. So turning to you, Stephen, could you, because as Jafar mentioned, the main reason for the consultant to stay away from a fitness for purpose warranty is because this is not insurable generally under many jurisdictions. Could you explain to us why, from an insurance perspective, fitness for purpose is not covered, while reasonable skill and care is covered?
Okay, and yeah, so thank you, Vincent, and again, really excellent introduction from everyone there, which actually links into what I'm saying. And as we often know, the insurance industry can be very reactive rather than proactive, and there's a lot of sort of stable doors closing after horses have bolted. So often the insurance industry does react to construction project losses, and that sort of drives a lot of behaviour. I think to sort of go back and to echo Jafar's earlier comments, we're very fortunate to have a very geographically diverse group of attendees here today. So whilst I'm going to try and explain why fitness of purpose isn't generally insurable in professional indemnity over the next 5 minutes, I'm very conscious that in certain jurisdictions, parts of the French Decennial Code, some of the codes in the Middle East, Australian consumer law, etc., does have some nuances around that. So there will be some jurisdictional differences to what I'm saying, and I'll let you shoot me down in the Q&A. But I think if we kind of go back to first principles, if we look at when architects and engineers started to more commonly purchase professional indemnity insurance some 40 years ago, those insurance policies were fundamentally designed to provide cover for claims against design consultants, which was strictly as a result of their negligence in the performance of their professional services. I think what's also fair to say is that the insurability position under PI policies was a lot simpler when either the architect or the lead design consultant was directly engaged by the employer. And so you had a contract based purely on the provision of professional services. And that sort of really links into what Pieter was saying around the design and build teams. And I think what we've seen in practice over the last 20 years or so is with the rise of design and build contracts, you have got this situation where there's a real blurring of the lines of responsibility around reasonable skill and care between the contractor, who has a design responsibility, but also a sometimes conflicting obligation to ensure that the end works are fit for purpose, and that's just a very hard piece for them to balance. But I think going back to what Jafar said, we need to remember that consultants are purely providing a professional service. They're not building a product, and it's for that reason that PI insurance doesn't cover faulty workmanship or any losses relating to defective goods and materials. What we saw in the 80s and the 90s was that when design and build contractors started to more commonly purchase their own PI policies, the insurance market faced a volume of losses because of some of those commercial and different legal liability positions. And this led to a number of now market standard exclusions being applied to PI wordings. And the reason for that was to ensure that we were always restricting claims payments back to those directly arising from the provision of professional advice. So they were looking to not cover fines, penalties, liquidated damages, and other express contractual terms. What that also caused was a real sharp focus into how PI policies had developed their insuring clauses to respond to claims. So professional indemnity policies tend to operate in one of two ways. I guess the sort of main and original format is an insuring clause which responds to third-party claims arising out of a negligent act, negligent error, or negligent omission. So really mirroring that sort of reasonable skill and care position. But what happened through the sort of 80s and 90s was that design consultants, particularly those working internationally across common law and civil code jurisdictions, managed to negotiate PI insuring clauses which indemnified them for claims arising out of any breach of their civil or legal liability, but again in the performance of their professional services. And whilst this was very sensible for a global firm undertaking projects across a range of countries, it also coincided with a move away from design firms being able to negotiate work on their own standard terms to the imposition of more onerous contractual terms and elevated duties of care from employers and contractors. So again, what we saw was that professional indemnity insurers ended up paying out sort of multi-million-dollar claims that were often unrelated to a design consultant's negligence and instead often caused by a pure breach of express contractual terms. And again, going back to some of the points that Pieter raised, we've sort of seen a prevalence in the UK in particular over the last 10 years of large claims arising out of energy from waste or waste to energy sort of process plants, where actually the genesis of the loss for the contractor was sort of more around performance output rather than there necessarily being any underlying issues in some of the engineering design. So where that's all manifested itself back to is that there's now a current and market-wide practice of restricting those wider insuring clauses via an exclusion for specific contractual liabilities which are over and above the legal standard of care which would have existed in the absence of the contract. So in other words, taking it all back to reasonable skill and care. Just picking up on your points, Vincent, I mean, the main reason that PI insurers will not cover fitness of purpose is that they do see it as a strict liability obligation. They never intended to provide a blank check in respect of any form of contractual liability. But as you say, I think the sort of really challenging point is that if a consultant agrees to a strict liability provision such as FFP, it's then judged against an objective standard, and if that part of the works fail, they can be liable regardless of whether or not they exercise reasonable skill and care. The challenge for PI insurers is that these strict liability obligations take away the burden from the claimant of having to prove negligence, that they've breached any of their professional services. And again, if we go back to how professional indemnity policies are constructed, they are there to protect claims against a consultant or a contractor from a third party. So it's a fundamental requirement that the PI insurer has the ability to reasonably defend a claim based upon a common law or legal liability position in the relevant jurisdiction. So just another reason why they won't cover FFP obligations. I think there's arguments on both sides. There's the sort of transfer of risk is always going to leave one party probably feeling slightly out of sorts. But I think what I would say is, and sort of echoing one of Jafar's points, is consultants aren't asset rich. If they're forced to accept uninsurable terms, they then risk becoming insolvent. Again, we obviously have some differences between whether insurance policies are placed on a claims made or losses occurring basis. But if we look at a broad section of the world where PI policies are placed on a claims made basis, that means that if there isn't a current policy in force, there is no protection for any prior projects completed. So I think, again, if we sort of look at the wider sort of global construction community, this is all about strong partnerships with competent groups of contractors and consultants and design professionals alike. And it's actually in employers' interest to sort of have those competent and sort of technically skilled consultants continuing to work rather than sort of burying them on one particular loss, because otherwise they're going to lose the protection for all the other thousands of projects that they've completed. And I think what I would say in practice is that most claims do stem back to something that's covered under a PI policy. So really what we're looking to do is to avoid consultants effectively picking up the can for sort of project losses that often manifest themselves elsewhere within the construction program. But that's probably very much in the hands of the lawyers and the commercial experts, Vincent. So I'll pass back to you.
Okay, thank you very much, Stephen, for that. I see that we have some minutes left for questions from the floor. So there's been several questions. One question I would like to raise to you, Jafar, as a start first. The question about a consultant who is largely involved in the project preparation stage, during the pre-design stage, so feasibility study, then the design, then the tender stage for the works contract, and then the consultant is also involved as being the FIDIC engineer, typically supervising the works execution. In that context, where the consultant is broadly involved for the whole project lifeline, would not it be reasonable then to give to the consultant a fitness, to ask a consultant to give a fitness for purpose warranty?
And you know I'm going to say no to that, Vincent. No. Okay, so to answer that in a little bit more detail. So going back to what I was saying, and then a potential solution. So the first thing is I still say no because of the fact, and actually we have a live project which I'm not going to go into a great deal of detail on, but there is a live project where we did take all of that, and there are still problems, but the problems have been shown to be in the workmanship. Even though we were on site, even though we supervise the works, as those consultants out there will know, when you're supervising the works, you don't supervise every single aspect of the works. There are so many aspects of the of workmanship that the engineer is not involved in. It's still, in my view, it's still inappropriate to ask the engineer to take on the fitness for purpose obligation. That's one. Secondly, coming back to Stephen's point, it is still uninsurable, and even if we were to agree, so Vincent, your point about state of the art, even if we as a consultant decided to take the risk on the basis that we'd done the work before, it was relatively standard, it's not really sophisticated, all the standards have been checked, etc. If we were to then accept the fitness for purpose obligation on the basis that there's still very little risk for us, as Stephen will confirm and a lot of other consultants will confirm, it still opens a door for the client to bring a fitness for purpose claim against us. And if it's a fitness for purpose claim, then all that happens is we end up with an insurance coverage issue with insurers, because then we're trying to work out, well, is it still a breach of reasonable skill and care, because a claim has been framed as a fitness for purpose claim, not a negligence claim. And then thirdly, just coming back to Peter's point, because I think Peter raised a really good point, and so did you, which is that what do you do when in a situation where nobody's at fault, that the engineer has complied with the standards, the contractor, and as Peter said, agree with your point about the judgment, which is that they say, well, the contractor should have checked. Why would the contractor have checked if everyone is assuming that the code is correct? So contractor's not at fault. The engineer's not at fault, and the client has paid for something that they haven't gotten. And so I would have thought that in a way, if you look at force majeure, I'm not saying it's a force majeure event, but in a way, the way that force majeure works is if no party's at fault, the parties share the loss, they share the pain. And I would have thought that this is a typical scenario where actually all the parties should bear the pain, because it's no one's at fault, but there has to be a solution there, and it can't all sit with the employer. It shouldn't all sit with the contractor, and it shouldn't all sit with the engineer either.
Okay, thank you very much, Jafar. Peter, over to you.
Yeah, just following on what Jafar was saying and linking it to kind of the PI insurance of Stephen. What is also interesting in that case, and that's in a way my guideline as an employer, I also look at the PI insurance and caps of the different parties. And what I sometimes find strange, but commercially fully logical, if you have a main designer, the consultant, which has a fairly large design contract with a fairly large PI insurance coverage, and he's getting checked by a bureau de contrôle or an independent checking engineer, or in this case, DNV as a certification agency, their checking fee is much smaller, hence their PI insurance coverage is also much smaller. And then if both parties get into a technical discussion, I really bring that to a head, because if the consultant follows the checking engineer, I may have only recourse against the checking engineer with a smaller PI insurance. And if the checking engineer follows the consultant who has a bigger PI insurance. So my commercial technical logic is I listen to the party who carries the most risk in making the decision. And that I find often kind of snowed under in these kind of discussions. And so it's consultants need to be careful with checking engineers, and to then make very clear as to if we're following a certain instruction or an advice, is it an instruction, and who's finally carrying the liability? And if something goes wrong, which PI insurance will be tapped? And then the French system is then a bit more clear, in which everybody would kind of get dragged into the bathtub together.
Yeah, of course, but the French system is of course a specificity internationally when there is insurance coverage for fitness for purpose warranty, but that's basically because all of the actors are under that mandatory insurance obligation at law, and that of course gives the financial strength for the insurance industry in France to cover that risk, but that's a specificity not yet applied worldwide. Conscious of the time, we have to wrap up now. Before I leave the floor to James for a few concluding words, just a few questions which were highlighted from the participants, and I would like to answer briefly. Is the White Book working well if the consultant is an employer's representative in the Silver Book or in the Gold Book? The answer is yes, and you can look at subclause 393 where the consultant is not necessarily the engineer but can also be the employer's rep, and under a Silver Book or under a Gold Book, the employer's rep, despite being the employer's rep, will still have to make a fair determination, and so the requirement of fairness is also enshrined in clause 3.9. Is there any partnership between GCT and FIDIC? No partnership ongoing, although we have discussions, but no with this institution like others, but no specific partnership. What are the key points that differentiate White Book from other FIDIC books? The White Book is services specific, while red, yellow, silver, green, etc. are work specific, and as a result you've got specific services obligations set out under the White Book, such as clause 3.3, the standard of care, reasonable skill and care is not something you find under works contract. You have also a lighter contract machinery for dealing with variations, for example. There is no specific claim provision with time bar and etc., just because again we are dealing with smaller capital value services contract, and therefore you cannot afford to have a dedicated contract manager on the job as you can do under a Red Book, Yellow Book, or a Silver Book. I saw also the question whether FIDIC is still intending to publish an EPCM form of contract. Yes, we have a task group for that, and the publication is expected for 2026. Apart from that, what did I spot again? Advance warning mechanism also in the White Book. Any consideration given to that? There is one. You can look at subclause 4.3.3, and this is basically a mirror provision of what you have under Red Book, Yellow, and Silver Book, clause 8.4 for advance warning. Is White Book applicable for both lump sum and time-based contract? The answer is yes, and it all depends on what you will have set out under appendix number 3. But typically, consultant services are either lump sum or time-based. Time-based being the typical scenario for construction supervision services. And finally, why White Book is not more used by development banks, you will have to ask them. Joke aside, from discussions we have with the banks, most of the time the point coming back is that they are already using their own form of services agreements for many decades and are happy to continue doing so. But there are discussions ongoing. We discuss with many of the banks also to show to them the benefits of using the White Book, especially for this consistency of role between the White Book, the consultant having a White Book contract with an employer, and then the consultant having to act as a FIDIC engineer under the works contract. And while the banks use works contract, FIDIC forms for works contract, that would make perfect sense, of course, to have an harmonization of role and responsibilities by using a FIDIC White Book and to avoid any gap. So on that note, I would thank all of my esteemed panelists for their time. Thank you also to all the participants for your questions. Apologies if we have not been able to answer all of them. And now I will now hand over the floor to James for some concluding remarks. Over to you, James.
Yeah, thank you. Thank you very much, Vincent. And I would like to take this opportunity, first of all, to very sincerely thank our panelists. Excellent choice of panelists, a very, very good mix, looking at the White Book in different perspectives. Key amongst them, the consultant. Thank you very much, Jafar, for your very, very useful insights, where you're coming from as a consultant. And then Pieter, special mention because you have been on the contractor's side and you're now on the employer side. So you see it on both fronts. And I think that's a very, very big benefit. Stephen, as a consultant, we always like to have the insurance behind us because of the reasons that have been explained here today. And it's good to understand what is admissible and what is probably not admissible in terms of coverage. And perhaps those kind of insights then tell us, as we look at these contracts, the relationships that we have between the parties, what risks there are. The fact that this is the 5th edition of the White Book means that FIDIC continues to improve the editions. The first one, 1990, now we are 2017, we have the 5th edition. But I think one of the key things also was the fact that, especially in the case of the employer, that they do find themselves having to calibrate here and there. And in so doing, still trying to make sure that they maintain the balance of the risk. I like the fact that when it comes to issues to do with the consultant, we know what our capabilities are. And I think, Jafar, I would not wish to repeat what you have articulated very, very well, including some of the regions where FIDIC contracts are used extremely well. I could also not fail to recognize the challenges that are posed by the construction interfaces as articulated by Stephen, challenges of unaligned contract terms, and then also the fact that the costs, huge costs that are sometimes incurred in defending claims which the insurance must obviously take into account. The topic of fitness for purpose, I think I would not even want to go further. It's been well articulated. And I like the case that was actually brought forward as to the complexities. Yet the legal interpretation is that whilst there are reasons that may not seem to be attributable to the employer or the designer, legally the risk or the liability is still with the contractor. So I would like to take this time to also thank the panelists. Sorry, not only the panelists, but also the participants. Thank you very much for your questions. Thank you very much for tuning in. I see we still have over 300. And I'm hoping that even as we go further, you will still be joining us in the future webinars. So in terms of where we are with the webinar series, which as you know are free, we have another one coming up in June 18th, on June 18th, 2024, collaborating to combat corruption. This is obviously a very big challenge in the construction industry. And then we would like to invite you all to the official FIDIC Regional Contracts Users Conference for Asia Pacific, 29th to 30th of May. Kindly book online, and this will also be online. We also have the State of the World reports. The next webinar will be on 13th June 2024. Please feel free to join us as we discuss tomorrow's transportation and the decarbonization challenge. I would also like to add, obviously, the FIDIC Global Infrastructure Conference coming up in September in Geneva. Please feel free to check the FIDIC website and feel free to book early. I would like to also take this opportunity to thank the staff of FIDIC who have put this webinar together with the chair of the Contracts Committee, Vincent, our moderator. Thank you very much for your tireless effort to make sure that these contracts continue to improve and also not just improve, but also improve the industry in terms of execution of those contracts. So on behalf of my president, Catherine, my colleague, Vice President Alfredo, our CEO, Nelson, and the rest of the FIDIC family, I want to say thank you and wish you a very good remaining part of the day. And for those who saw the eclipse, you may wish to share your experiences. Thank you very much.
Thank you very much. Bye-bye.